Fourth case on this morning's docket, case number 117436, State of Kansas v. Dale M. Willis.
May it please the court, Jennifer Roth appears on behalf of Dale Willis. I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
By way of introduction, it is undisputed that Dale Willis did not shoot and kill Jarrell Carter outside a busy bar in Overland Park. But 3 months after Mr. Carter's death, the state charged Dale with first-degree premeditated murder under the theory that Dale communicated in some way to his brother, James Willis, to shoot and kill Mr. Carter. In pursuing its aiding and abetting theory, the state called 36 witnesses. Not a single one heard a verbal directive from Dale to James to shoot Mr. Carter. Dale's defenses were that he did not direct James to shoot Mr. Carter, but if the jury found that a communication did occur, then it was in self-defense carried out by James. The jury convicted Dale as charged. Dale asked the court to sentence him to the hard 25, which the court denied after making comments about aggravating circumstances and a not required by the law mitigating circumstance. Dale will be 83 years old before he is parole eligible. In our brief, we raised 9 issues, which is an overwhelming sounding number, so I sort of grouped them together. And basically the reasons this court has to reverse these convictions basically fall into 2 categories. 1, the information that was incomplete or incorrect provided to the jury, i.e. the law that they were supposed to use to consider Dale's fate. And secondly, errors made regarding the admission of certain evidence. It is also our contention that overall, when the court considers these errors together, if you do not independently find them to be warranting reversal, that all taken together, that in fact it does warrant reversal. So I guess I would start with the instructional issues that we raise. The more I think about this, the more concerned I get. And that is all of the things that the jury was not informed about the law. For example, with regard to, obviously the entire case was about aiding and abetting, yet the jury was not told, wasn't given sufficient information about what that entails. The jury was not told that the mental culpability required refers back to the elements of intentionally killed and premeditation. Even more troubling is that the jury wasn't told in plain terms that Dale and James both have to be acting with the same intentions. They have to share the same intents. It's not enough if one of them thought that they were acting in self-defense and one of them thought that they were acting with an intent to kill. It's not enough if at any rate, they were not told that in any shape or form.
What's our standard of review on, well, let me back up. Are you objecting to, on appeal, to any of the instructions that were given? Or are you just making an argument that the jury should have received additional instructions?
Our issue is that the instructions as given, that the aiding and abetting instruction and then the self-defense instructions, that they did not completely state the law that the jury needed to have.
And that leads to my follow-up, which is just what's our standard of review and why isn't this invited error? Because as I understand it, these instructions as given were exactly what the defendant requested.
First of all, it's our contention that we don't even think it's a clear error standard. We actually think that this court should be considering this under the constitutional harmless error standard.
Well, let me just ask a factual question. Is what I recited just a minute ago accurate, that the instructions as given were the instructions that were requested?
I take issue with the word requested. Here's what happened, which is basically what happens all the time in trial courts in the state. The judge tells attorneys to submit jury instructions and gives them a deadline. Sometimes you, even at your pretrial conference, we'd have to fill out these forms saying whether or not we were going to be requesting certain instructions. This is something that's required of defense attorneys, even though they haven't revealed their defense, started their trial, heard what any of the state's evidence is going to be. So basically what happens is, to comply with the court's order, you submit a list of pick numbers, maybe sometimes the language, and maybe sometimes people do ask for specific language in advance. And that's what happened here. The judge ordered the attorneys to file jury instructions. And in fact, at one point, the state asked the court to remind them to do that because they hadn't done it yet. And the court referred to those as proposed instructions.
It sounds like the answer to my question is yes, these were the instructions that the defense requested, but you're objecting to the process.
No, I still take issue with the word requested. Those are the instructions that they submitted.
Okay.
Those are not instructions that they actively pursued or truly invited or even requested. That's something that they did to comply with the court's order that they do so. There wasn't any conversation about the content of those.
Do we have to change our invited error rules to reach the merits of your jury instruction claims?
I don't think you need to in this instance, because these do not meet the definition of being actively pursued or requesting. They
were given the opportunity to submit whatever they wanted, were they not?
They were, and they submitted standard pick instructions.
Was there anything preventing them from updating that or amending that later?
No.
Okay.
Like at the instruction conference before the case went to the jury?
They could have done that. I wish they had done that. But
And they didn't object when the judge agreed to give the instructions that they had submitted.
That they said no objection. Both sides did. That's correct. I guess an additional thing that continues to trouble me is that the consequences, when you're considering an invited error, the consequences fall on the defendant. The accused, my clients. And that what happens is all of these expectations and consequences fall on the accused, not on the party who has the burden, i.e. the state, not on the entity that has the duty to instruct the jury on the law, i.e. the court. It's not like we ever talk about invited error by the state or the court. It's the court who has the duty to instruct and has the duty to know whether these instructions fully give the jury the law they need to have. And so it is confounding to me why this consequence and burden always falls on the person that's the accused, who doesn't even have the burden and who doesn't even have the duty to tell the jury what the law is. So I do not think that invited error is at issue here. At any rate.
And I understood then you also do not think clear error is.
Right. Because it is our contention that the problems with these instructions, the law that's not contained in there, that the jury does not have with regard to the aiding and abetting and the self-defense instructions, that those implicate Dale's constitutional rights, and that's why we do not believe that you should even use the clear error standard that's in the statute, but instead use the constitutional harmless error standard.
So you want to rewrite all of our case law on jury instructions to basically say, for the first time on appeal, defendant can challenge any jury instruction that was given and the constitutional error standard will apply.
If the complained about error implicates a person's constitutional rights, i.e. to have a jury decide every element of the thing that you're charged with, then yes, I think that you should use the constitutional harmless error statute or the constitutional standard for that.
Even if the accused never asked for those instructions, it's because the judge failed on his or her own to use them. That is error, and then we look at the constitutional error standard to judge that.
Right. Yes. If I'm understanding this correctly. Yes. Because again, it is not Dale Willis's duty to instruct the jury on the law. It is the court's. And the court can do the exact same thing that this court seems to be saying that Dale should have done, which is consider whether these instructions really do fully say everything that the jury needs to know. That is the court's duty.
Let's assume, counsel, before you run out of time, assume you convince us to, in Justice Biles' words, rewrite our standard of review on jury instructions. Why isn't this still harmless, even if we apply the constitutional harmlessness test? Under these facts, I'm having a hard time seeing how a jury, even properly instructed from your perspective, could reach a self-defense.
That's not the only instruction I'm talking about. First of all, I do think that there is something. I'm also talking about the aiding and abetting instruction, which was the entire theory of the state, which is the only way that the state could charge Mr. Willis. And there are multiple problems, as we've set out in our brief, with what that instruction didn't say. And that comes down to the very heart of what the jury was to decide, i.e., was Mr. Willis guilty of premeditated murder? And if they were not given all of the law that is a part of that decision that resulted in Dale having a hard 50, then that is definitely harmless. If they are not given all of the law that they are required to find. So we may have a little bit more room to argue about the self-defense ones, but I just think that it is, it's just clear that the jury, in deciding whether he was guilty of murder, was not informed about all of the law, and that is not harmless.
And which specific portion of the aiding and abetting law are you hanging your hat on?
There's at least three different ones. The fact that that when the aiding and abetting instruction talks about mental culpability, that's not defined anywhere. And so jurors don't know that refers back to the intentionally killed and the with premeditation in the elements instruction. The second thing is that they are not told in plain words that Dale and James have to be acting with the same intents. And third, they were not told that Dale has to knowingly associate with the unlawful venture and participate in a way to facilitate that, i.e., the meticulous, extensively planned killing, to borrow some words from the last argument. The juror was not told any of those things. And as this court often says, jurors don't become imbued with this information when they are sworn in as jurors. They have to be informed of it from the trial court, and that did not happen here. And this, as far as reversibility and why this isn't harmless, this is not, despite what the state argues in its brief, this is not a case with overwhelming evidence. Dale was not the shooter. He didn't give James a gun. There's no evidence he disposed of a gun. He didn't give James a ride to the Roxy. He didn't ask him to come to the Roxy to help him with Mr. Carter. And there's no evidence that Dale gave James anything except for maybe a ride away. Well, we know he gave him a ride away from the Roxy. And so it's not harmless. This is not an overwhelming case. And so that is why it was so crucial for the jury to be informed on the very law it needed to determine whether Dale was guilty as an aider and abetter.
To follow up on a point that was raised earlier about you're asking us to redo our case law, it's not just case law. It's KSA 223414, in which the legislature has set out the procedures in distinguishing between clear air and others. So are you therefore asking us to declare that statute unconstitutional?
That's the statute that says you can raise the error for the first time on appeal if it's, that's the one.
Among other things,
Right.
yes.
Right. I'm not, nobody needs to rewrite that statute or even all of your case law. That's my position. Because what I'm saying is that there's still going to be times where you could apply clear error. And there'll still be times that, I'll live with it when you say it's harmless. But when what you have is that the jury is not informed about all of the elements that it has to find that the state proved beyond a reasonable doubt, then that is not clear. That should not be subjected to clear error. That implicates a constitutional right and should be given the test accordingly.
Thank you, counsel. Do you have any further questions?
Counsel, what role do you think defense counsel should even play in a jury instructions conference? Do you think they have no responsibility at all?
No, I do think they have a responsibility, and
don't they request a jury instruction when a judge says to them, counsel, here are the jury instructions I've prepared based on the evidence presented in this case, my understanding of the law. Take whatever time you need, go through them, we'll get back on the record, we'll talk about it. You get back on the record and you look at counsel and you say, do you have any objection to the instructions as proposed? And they stand up and say, Judge, they look fine to us, no objection. Isn't that a request of the trial court to give that instruction then?
I still I can't agree that it's a request. To me, it's not an objection. I don't object to giving this instruction.
But they can request additional instructions at that point as well, and for that matter, all through the trial. As the evidence comes in, as their theory either is allowed to proceed or not, depending on that evidence, etc., all of that, they have opportunities to seek. What you're really talking about is additional instructions here. You're saying that what was given was incomplete.
Right.
And you can't quarrel with the fact that defense counsel could have at any moment really alerted the trial court that additional instructions were required.
I can't argue with that.
Okay.
And to answer or to address both of those questions, I can appreciate that is frustrating. I used to be one of those people, although sometimes I tried to do better. But the fact is that all of the consequences of that should not fall on the person that is the accused. At the end of the day, it is still the trial court who has the duty to know what is the full law that the jurors need to have, and that the consequences of them not getting that law shouldn't fall on the person that's looking at the hard 50.
Thank you, counsel.
Thank you.
Mr. Chief Justice, and may it please the court. Dale Willis was accorded a fair trial in this case. He was able to present his theory of defense essentially unfettered, from jury selection through opening statement, through every one of the state's 39 witnesses, including the very first one.
Wasn't one of his theories of defense that James Willis acted in self-defense? And wasn't he prohibited from making that argument?
He briefly made that argument in closing, that James Willis acted in self-defense. But he was, that was objected to the extent that the instructions that he himself requested did not comport with that, because the self-defense instruction that was given to the jury explicitly stated the defendant argues he acted in self-defense.
If James had been acting in self-defense, or if there was evidence that would have supported that claim, isn't that a legitimate defense to the crime which Dale was charged with?
It is. It is, and he could have asserted that, and he could have tried to develop that through the evidence.
Why can't he argue it at any point in the trial?
Because arguing it was contrary to the instructions that he requested. He, to the extent that he attempted to argue that during the trial, it fell flat. It went nowhere. There wasn't evidence to support it. All the evidence kept coming back to the contrary, that the two were acting in concert, that it appeared as though there was communication between them, that Dale didn't react to the gunshots that James fired at the victim.
So we go back, that issue turns, it sounds to me like you're arguing, at the same point that the jury instruction claims turn, which is that the instructions which Dale requested were in fact given.
Correct. They were the instructions that were given. And aside from the aiding and abetting instruction that a lot of discussion has already been had about, the self-defense instruction that's the subject of issue 3 is a pattern instruction. The state objected to giving that instruction at the outset. It objected to giving a self-defense instruction all the way through this
Just
trial.
as factually inappropriate.
Because it was factually inappropriate, precisely.
Because he had made no claim that he needed to defend himself personally, right?
Correct. Or that James Willis did. He made nothing more than argument that James Willis did. There was no evidence to support that. Factually, there was nothing there. One of the prongs of self-defense is the subjective prong. It was entirely absent because neither James nor Dale Willis testified in this trial, nor did any of their statements about the events of that night come in.
That would have indicated that they might harbor a subjective belief.
Precisely. There was zero evidence of that. So the state opposed giving a self-defense instruction at the outset.
I understand.
Almost the entirety of the jury instruction conference that was held at the close of evidence before closing argument centered on the self-defense instructions. The bulk of that conference, when you pull up the transcript, 30 or 40 pages of it are all a debate about the self-defense instructions. The state opposed giving them the entire way. But the defendant's proposed instructions, which he filed before trial, a week before trial, included a self-defense instruction, and that instruction is the one that carried the day at the conference, and it was given to the jury. And the state does continue to assert that to the extent that he now argues any error existed within that self-defense instruction, it was absolutely invited. It was invited by him proposing the instruction to the district court before trial. It was invited by him vigorously arguing in support of that very instruction at the close of evidence. This court has said merely acquiescing to a state's proposed instructions or the district court's proposed instructions may not trigger the invited error rule, understandably so. But the defendant in this case did much more than merely acquiesce. He did more than acquiesce because the state never proposed the instruction in the outset. He did more than merely acquiesce because there's 30 or 40 pages of him arguing vigorously for this instruction as it was worded to the jury. This court, just a few years ago in 2016, I believe in the Sasser case, elaborated more thoroughly on when the invited error doctrine may be triggered. And one factor that it stated may weigh in favor of a defendant and may weigh against triggering the invited error doctrine is if a defendant proposed the instruction, but he did so before the state's case went through, and he did so without the information of how the case had progressed at hand. And so, for instance, on a lesser included offense, if the evidence came out contrary to what he may have perceived at the outset, then perhaps that instruction that he proposed at the outset would not be invited error later if the case progressed differently. But here it didn't. It didn't progress any differently. He sought a self-defense instruction before trial, and the case progressed with him doing all he could to elicit that evidence and make that argument from every stage of the case, from jury selection, opening, all of the state's witnesses, and then putting on his own witnesses to the same effect.
What about the aiding and abetting instructions?
The aiding and abetting instruction was a PIC instruction. It carries that gloss of already acceptable, it's already been deemed a correct statement.
Not on the merits, on the invited error.
On the invited error. Admittedly, my invited error argument is not as strong there because there wasn't a long debate about it.
But you're still advancing an invited
I
error.
am. I'm still advancing it because he requested that instruction, and the instruction he requested was given. And he never gave the district court or the state any opportunity to debate that instruction because it was the one he recommended to the court, and it was the one he had no objection to at the conference. To the extent that my argument is not as strong as the self-defense one, it only relates to the fact that at the conference there was
on
no
aiding
objection.
and abetting, a clarification question. What on the state's theory? Did the state choose a particular subset of aiding and abetting when it advanced its theory of guilt to the jury? In other words, advises, hires, counsels, procures, or was it just general?
It was general, but to the extent there was never any testimony or argument about hiring his brother to do it. But to the extent he advised him to, or procured him or counseled him to, that would all be wrapped into the...
But that was the state's theory as opposed to a more general just participated.
Absolutely. It was much more than mere participation, because when Dale Willis was already at the nightclub, that's when he texted his brother and said, "Sucka here." And then his and the testimony was that referred to another individual at the club that he had a rival with, that was a rival. And then James Willis, there's a bevy of communication between James Willis and other people as James Willis is trying to obtain a ride to get to the club. And he's talking about it being an emergency and he needs to get there quickly. And so he texts and communicates with several other people to get a ride quickly to the club. He arrives, then they communicate by text. And there's a phone call, which obviously we don't know the content of. But there's a whole host of communication between those two brothers leading up to the confrontation on the sidewalk when Dale punches the victim, and then James Willis getting out of the car, then briefly being outside the club. And then the victim in this case got in his vehicle and proceeded to back away or roll away from the curb. And that's when Dale and James Willis paced him, paralleled him down the parking lot.
And my understanding is there was evidence that Dale was pointing at the victim, and then James essentially unloaded his clip into the passenger side of the vehicle. Is
That's
that
exactly
accurate?
That's absolutely exactly what happened, and it's shown on video. There's a point on the video. There was disputed testimony, but testimony nonetheless that within the video you see the two brothers put their hoods up as they're walking down the parking lot. As Gerald Carter is attempting to leave and get away from everybody, he's backing down, and the two brothers then parallel the car as it rolls down the parking lot, and James unloads his clip, as you stated, into the passenger side of the vehicle, killing Gerald Carter. While he does so, there's no indication on the video, there was no indication by the testimony that Dale Carter ever flinched, ever reacted to those 11 rounds being unloaded into that car. After the brothers then dispersed and left together. So the state argues there's abundant evidence that he counseled, advised, procured his brother James Willis to come to the club that night and commit this killing. So that's the state's arguments on the two jury instruction issues. I would also like to note that the defendant within his brief argues against application of the invited error doctrine, in part because he argues, and it's on page 7 of the reply brief, that for it to be invited when the attorneys submit PIC instructions as requested by the district court, he's arguing that wasn't a request or a proposal or anything of the sort. But then he argues on page 7, to hold otherwise would place defense attorneys across the state in an unenviable position of having to defy district court's requests to submit instructions. We're not asking them to defy it. We're asking them to submit the instructions they want, even if they differ from PIC. That's not an unreasonable request. The reply brief goes on to state that it's asking that to do so, to apply the invited error doctrine, would encourage defendants to supply those instructions per the district court's request in order to potentially preserve unknown future appellate arguments, or alternatively, having to become not only trial experts, but appellate experts in order to effectively counsel their clients. That is what the state's saying. They're absolutely duty-bound to be experts when they're representing their client in a murder case. That's their role. They are obligated to know the law. They are obligated to know preservation requirements. They are obligated to know when a contemporaneous objection is required. That's precisely why the invited error doctrine is available. The invited error doctrine is available and present and applicable because in the event that there is some sort of error, he should jump up and tell the court that so it can be corrected. And so we don't do this. So we don't spend years litigating after the fact and doing new trials. It should be corrected on the spot, and a correct instruction, if he argues the existing ones were insufficient, should be given then. But the time is not appropriate. It's not appropriate to just sit back and acquiesce to whatever the district court's going to do and then come back later and say, hey, I'm crying foul now because
Counsel,
they didn't do what they should.
Let me move you over to prosecutorial misconduct. And this
Yes.
may be a little nitpicky given the way the argument's been going, but I want to focus on the prosecutor's use of the term street law, and I don't see that there was evidence admitted that, at least from my perspective, would fit under a term of street law, which I would be some sort of sociological culture, if you will, as opposed, what I saw in the evidence was just references to revenge, but I didn't see that as a street law thing, and so was I missing something when I looked at it? That seemed a little far afield.
I understand where you're coming from, but I believe there was testimony and evidence to the effect of individuals taking respect and disrespect very, very personally, and resolving disputes between themselves, and it getting physical and violent, and not resorting to other remedies that might be available to other individuals. So,
within a group, as opposed to those particular individuals. That's I mean, I understand revenge. I understand those kind of motivations.
Right.
It seems like to say street law, it's got to be applicable to a certain, at least sociological group. You see where I'm getting at? And
I do see where you're getting at. There was testimony here that the various rivalries here concerned other individuals to the extent that those rivalries could trigger violence between the parties, and that those parties often resolved those disputes among themselves, oftentimes resorting to violence or carrying firearms, carrying guns. There was testimony about that. There was testimony about Brown himself testifying about potential violence. The defendant himself talked about this imminent threat that was posed, he argued, by Gerald Carter. And so to the extent that the state talked about that, that was a reasonable inference from the testimony of Tyrone Brown when he talked about the culture that existed between the brothers, Dale and James Willis, and their recording label, and other players within the rap community that were present at the club that night. Disrespect occurred between the parties regarding a photographer that was on the sidewalk. That's when the punch was thrown, and so on. So to the extent that that one-off line of the prosecutor in closing referring to street justice, it was referring to resolution of issues between these parties when they take actions into their own hands and resolve it with the use of firearms and threats and intimidation and so on.
Is it more accurate to say it's the code of the street and the street law?
That would be a fair characterization, absolutely. That was the code between these different individuals, these different groups, and how they resolve disputes among each other. The other claims of error regarding prosecutorial statements, one was about a joke that the state made about a lesser included offense that was given in the instructions, and the joke that the state made about if we're not doing our job as lawyers, if we're not adding and confusing things. This was a very trivial comment. It was never inaccurate. It was not error.
It's inaccurate to say that you're needlessly complicating a case by adding deserved lesser included instructions, isn't it?
We never said we were needlessly doing so.
I know. I'm saying that.
Yes, if we said we were if we said we were needlessly doing so, absolutely. That would be an inaccurate statement of law because those lesser included offenses were.
And you don't think trivializing it trivialized the enterprise somewhat? It's to be avoided. Wouldn't you agree?
It to be avoided, yes.
Yeah. It just seems its juxtaposition with that discussion is unfortunate at the minimum, I think.
True. Mm-hmm. But I think what we need to do when we're looking at statements like that is looking at the fact that this is a days-long murder trial where the parties are involved in it. They're wedded to the case. They're working on it for 10, 12, 14 hours a day. The jurors are there all day.
I certainly understand the need for even feeble comic relief in those circumstances. And I understand that it's your position that's all this was, and it was harmless if even error. But it just seems to me it's probably doesn't have much place in a murder trial.
Understood.
Okay.
And the state absolutely takes that to heart. There were several jokes made by defense counsel as well. There were jokes made not just during closing argument or about conference instructions. There were jokes made while witnesses were on the stand about them being experts and about them examining fingerprints on their own hands and about and so on. So it's not as though moments of levity were not sought only by the state.
Can you respond quickly to what I understand defendant's argument to be on sentencing, that the district judge improperly weighed aggravating factors.
Recognizing my time is limited, I welcome additional questions if you have them and if I don't resolve them quickly. My response to that immediately is, because the court found no mitigators existed in this case, there could be no improper weighing. Had the court found a mitigating factor existed, but then elaborated upon balancing it against some aggravators, such as not taking responsibility, then admittedly we would be problematic under Jolly and under recent case law of this court. But because no mitigating factor was found to exist by the district court, there couldn't be any improper weighing. It doesn't matter that the district court elaborated on what it saw as aggravating circumstances, because the lack of a mitigating circumstance foretold the inapplicability of the hard 25 that Mr. Willis sought. The only way Mr. Willis could get the hard 25 rather than the hard 50 was to assert that mitigating factors existed that were substantial and compelling. And when the district court found none to exist, that was essentially the end of the analysis. And when he elaborated on beyond that, it was surplusage, but it did not impact the fact that he found no mitigating factors to exist.
Any further questions? Counsel, what are you asking us to do?
I'm asking you to affirm Mr. Willis's convictions and his sentence.
Thank you.
Thank you.
In response to the state's argument and also a couple of questions, try and hit on a number of points. First of all, the state, just to kind of correct or clarify some things the state said about the facts, you probably already know this, but the bevy of communication that occurred between James and Dale and other people, and the rush to get to the club, none of that had anything to do with Mr. Carter. That had to do with somebody else, and all of those sorts of things occurred before Dale even got into it with Mr. Carter. So it's not that that Dale procured James to come to the club to kill Mr. Carter. That is not supported by the evidence.
I think, as I understand, one of your arguments is there wasn't, the evidence was not overwhelming, to say the least, that Dale had premeditated this killing. And then you connect the dots by saying, because the jury wasn't told that that was an element it had to find, this is reversible error. Is that a good summary of your position?
Yes. Okay. Yes.
Can you respond to the other evidence that the state recited that would have supported its theory that Dale met the premeditation element? The things on the video and so on.
The thing I would say about that is that those things were disputed as well. So the state said that it was the hoods were disputed. That's true. They were disputed. But another thing that was also disputed is whether or not Mr. Carter was trying to get away. And so if he's not trying to get away, but rather trying to make good on something that multiple witnesses heard him say, or the way he was acting, or I guess the street law, if the state's going to argue that this is about a culture or a street law or disrespect between the parties, well, that doesn't apply just to Dale and James. It also applies to
You're saying
Mr.
a reasonable
Carter.
juror could look at all this evidence and there's two possible explanations for it, basically.
At least.
And how do we know which one the jury picked if the instructions were wrong?
Exactly.
What about a point raised by opposing counsel, I'm assuming it's in the record, that your client pointed out the victim just before his brother shot him 11 or 12 times?
That was disputed somewhat as well. That had conflicting evidence as well. So, like, for example, the lead detective said, oh yeah, he pointed at him twice. But then she admitted that, okay, well, maybe one of those was like trying to break people apart. I mean, we're talking about a black and white grainy video. Then there was, and then there would be people that would testify about not pointing. So that was even disputed or had multiple viewpoints, if you will. Another point I wanted to make was about Justice Biles. No, I'm sorry. It was both of you. Justice Byer and Justice Biles about the comment that, we wouldn't be lawyers if we didn't complicate things. That's no joke. That's not levity. That is not just unfortunate. That is straight up, the state had just agreed that those instructions were appropriate, and yet then wanted to go in there and belittled them. That is not a joke. It's not levity. And as for the 9-day trial, and it's just one phrase in 9 days, you know what? It doesn't matter if it was 9 days or 3 weeks, whatever the case may be. If the wheels fall off at the end, whether that be through prosecutorial misconduct or the way the jury is instructed or not instructed, or cumulatively all the above, it does not matter if at the moment that Dale is supposed to realize these constitutional rights, if that is hindered or obstructed, whatever, by these errors, by prosecutorial error or the court's instructions, it doesn't matter. It doesn't matter. The wheels fell off. That's what happened in this case.
Counsel, you're well out of time.
Okay.
What are you asking us to do?
Well, first and foremost, we're asking you to reverse Dale's conviction and order a new trial. And as part of that, we would ask this court to reconsider its holdings that say that the self-defense instructions and the aiding and abetting instructions give the jurors all the information that they need. And alternatively, Mr. Willis asked this court to vacate his life sentence and remand his case for resentencing, because even in light of Powell, the court erred and also considered information that we believe implicates Dale's Fifth Amendment rights. Thank you.
Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. That